Welcome back to the Behind the Bricks podcast. Have you ever dreamt of launching your own development but felt daunted by the maze of contracts and clauses and potential disputes? Or maybe you're already knee-deep in a project and you want to make sure that you're protected from costly mistakes or hidden contractor fees or legal headaches. It sounds like you're in the right place. Today, we're going to take a deep dive into contract disputes with industry expert Paul Adelaide, and he's going to uncover how to protect yourself and how to avoid a £300 million claim. Let's get into it. Welcome to the podcast, Paul.
Thanks for having me, Chris.
It's an absolute pleasure.
Happy to be here.
So later on in the episode, we're going to talk about some of the real-life disputes and disagreements that you've had to deal with when they occurred, how much it cost those involved, and obviously how they could have been avoided. But before we get into that, tell us a little bit about yourself and how you got involved in such a niche role.
Oh, where do I start?
Try the beginning.
The beginning?
Let's go there.
All right.
When I was 5, I had some Lego.
Oh, there. Now, do you know what? Building's never really been a huge part of my life. I did a lot of stuff with my uncle. He was a tradesman. He did a few odd jobs outside of his normal work, and I just used to go and work with him, get a bit of money, did product design at school, but I never really thought about construction. But a little bit before I finished school, my older brother was doing an apprenticeship as a quantity surveyor.
Okay.
So as I was leaving secondary school, he was raving about it. He was like, this is the way forward, because they paid for his uni and they were obviously paying him a salary at the same time.
So was he more enthused about being a quantity surveyor or more enthused about somebody paying bills
I think
for
it was
him?
the money.
Oh, really? Okay.
Yeah, all right. He currently hates being a quantity surveyor.
Okay, so that's gone full circle.
Yeah. But I mean, he was on the money, because it was a great way to sort of get into the industry, having a income, a job that pays you, and you also get your education paid for as well. So because of changes to my work pattern, I ended up paying for like maybe my last year of uni, but it cost me about £6,000 in student loan, which I just paid off out of my salary. Didn't even notice it really. But yeah, so I basically left secondary school and just went straight into the workforce. So started doing quantity surveying. I've been doing it for 10 years, and most of the things that I've learned have been from being in the workplace, not really the theoretical stuff at uni or when I was at college as well. So I'd been doing that for a very long time, and I'd mediated quite a few disputes between the contractor and the client, because that was my main role, being that intermediary. So making sure the contracts made sense between them, the scopes, and then managing the project when it went on site. So when there were any issues, we would deal with the contractor, deal with the client, and try and get basically a place where they both agreed. And then we ended up working on a dispute it went a bit further. So it went to an adjudication, which is basically a step before court, where an independent assessor looks at the case and makes a decision. And we helped the client prepare their defense. And through doing that, I basically got opened up into the world of construction disputes.
Yeah.
Because it's a very niche area. And if you don't know about it, you probably wouldn't have even heard about it and heard the things that go on, because the cases are they don't get publicized very often unless they're like landmark cases, big cases, because obviously there's a lot of sensitive information that goes into it.
There's so many questions already that I can think of to follow up on this. Let me first ask, do people want to keep it quiet? You know, the people that are involved in the dispute, do they want to keep it quiet because they see it as like a fault that they're in this position, that they should have done whatever to start off with? It basically signposts bad preparation.
Not just bad preparation, it also signposts bad working practices. You know, for example, a lot of the cases are where people have done something wrong. You know, they've breached a contract, or they basically caused an issue on the project. And when they're having to pay out, it actually affects their business reputation. So they don't want people to know about that. That's why they're usually quite close-knit. They're very sealed. So if you're working on those kind of disputes, you're not even really allowed to tell people about it. So you'll know like about these companies. But
yeah.
Some of the money that they pay out as well is quite ridiculous. I was working on a claim not too long ago, and we were building up the claim, and the contractor was claiming for around almost 300 grand. 300 million.
300 million?
Yes.
That
for a delay.
That went a long way after 300 grand. That was a big increase.
Yeah, so yeah.
300 million?
Yeah, because of delays caused by what they're saying is caused by the client. So a lot of the time, construction disputes come from losses that a contractor's incurred or a client's incurred because someone's not done something on time or someone's not done something in the right way, and it's just had a knock-on effect. So you can imagine if you're going to, in a smaller scale, if you're going to a job, so let's say you're an electrician and you need to do some lighting, and you go to the house and you can't get in, or for whatever reason there's someone else doing work there that doesn't allow you to do your work, you still have a day's of wages that you are owed, but you couldn't do that work, so you have to come back and do it again. So now what would have cost maybe £200 for a day of work now costs £400. But if you scale that up to a huge team being delayed for months on end, then yeah, the numbers get pretty meaty.
Wow. Let's take you back a little bit, first of all, because you've used a phrase that I think a lot of people will be very familiar with, but I don't think a lot of people can actually explain, and that is the job of a quantity surveyor. Could you first of all, and I get that you've gone into a niche part of that, but a standard normal quantity surveyor, can you explain what their typical job role is?
So we count bricks. It's a very versatile role. We're essentially managing costs on a project. So the client has a budget and they don't want to go over that budget. So we do everything we can to ensure that the project stays in that budget. But because there's so many things that can affect the budget, we also have to manage a lot of other things. So for example, the program of the works can affect the budget quite a lot, because if you think, let's say a contractor has to hire a plant or some kind of machinery to do some work, anytime there's a delay, his hire cost increases and he passes that on to the client.
As well as labour costs for the people that are actually using the stuff.
Yeah, exactly. So our job is to mitigate all of those things. So we work with, project teams, project managers, designers, everyone, to try and keep those costs to a minimum. So it ends up being, we deal with the client, understanding what their needs are. We deal with the contractor, making sure they're not playing games, but at the same time, also making sure that they are getting what they need, because ultimately you want them to do a good job. You don't want them to go bust. So you're not trying to just take money away from them, but you need to make sure that they're doing things to the client's expectations as well. So it does become a very versatile role, and some quantity surveyors are simply just there to do payments. So how much does the contractor get paid?
Oh, right, okay.
But some quantity surveyors end up taking on other roles like contract administration, which means they're dealing with variations to the contract. They're dealing with extensions of time. They're dealing with the project managers as well. And, they might be the project managers themselves, essentially.
So would you say that, to sort of sum it up, you've got your schedule of works that are created before you start in the design phase, and then the QS, the quantity surveyor, their main focus is the accountability to that schedule of works to keep everything ticking over.
Yeah.
On time, on budget.
Essentially, yeah. Because one thing that people always don't realize as well is, so a client, in their head, they have a budget, but if they're not clear about what they want, then when it comes to that stage and they then add that clarity, it might cost them money and they might not realize. So we also have to almost manage people's expectations and be very clear with them. If this isn't detailed enough, there is an element of, you might have to pay an X amount. So we end up building in contingencies and saying to the client, if there's not enough design, if there's not enough clarity in your scope, you need to put some money aside in case you end up having to spend more money, because you said you wanted a kitchen but you didn't say what type of kitchen you wanted, and it went from a £3,000 kitchen to a £7,000 kitchen. So that's the main thing we do. And
so your role has sort of evolved, or you've gone down this niche of being involved in disputes. So the disputes that you mediate or you're involved in typically are between who?
So they would be between a client who's undertaking a development or
Yeah.
a piece of work.
So is another word for the client a developer?
Yeah.
Yeah, okay.
And then the contractor who's doing the work for them. So, it could be anywhere from a very small contractor who's got a small build team to a major contractor who builds hundreds of homes on plots. Generally speaking, when it gets to like the stage of disputes that I deal with, it's big contractors and big clients. And then the amount of money you're talking about is a very big amount of money.
So how do people protect themselves from being sued for £300 million? What's the correct way? I tell you what, there's two different structures which we learned from Natalia in the other podcast, and there's a structure where you've got the developer, and then that developer employs a main contractor, and there's that relationship. And then the other structure is when the developer doesn't employ a main contractor. They have, and this might be a smaller development, but the developer has the trades that come in, and the developer sort of manages those trades and keeps on top of those trades themselves. Yeah. So let's look at those two scenarios. So what would be the correct way for the developer? Because I guess most of the people that are going to listen to this podcast are going to be in that role, looking at it from a development point of view. What's the correct way that they should protect themselves?
So there's two parts to that. So choosing whether you hire a main contractor or not just depends on your expertise. If you're skilled enough to manage multi-trades, you've got the infrastructure to do so, you've got the systems in place to do so, then by all means you can do that because you'll save yourself some money. However, if you don't have the experience, you don't have the skill set to do so, you will lose a lot of money trying to figure it out along the way instead of having someone in the middle to do that.
Yeah.
And then the next way you protect yourself is by having a clear contract in place between yourself and who you're paying, essentially. So whether it be the trades or whether it be the main contractor who's managing the trades for you. And then there's several different trade-offs depending on which avenue you go, I guess.
Okay. How long does that take to put in place? Like typically, how long does a contract between, and again, let's look at the two different scenarios, between a developer and a main contractor, how long would that take to sort out?
That's a tricky question because it depends on how quickly you need things done. So things can move quite quickly if you're on a timeline. So for example, if we work for a local authority who's basically doing work to a school and it needs to be open before the school year starts, then they're on a time scale. So that will then determine how they proceed, how much detail they go into things before they actually get a contractor. Would
you say that because there's a time pressure, then typically they're the contracts that you would have to get involved in because there's been a dispute, because they haven't put enough time into making sure that everything's covered in that contract?
100%.
Oh, really? Okay.
Time issues are the biggest part of construction disputes. It's always about time. Either you don't have enough of it or someone's used too much of it.
Right.
So, but the issue is time costs money. So that's where it becomes a dispute, because if it was just time, then no one would really care. But,
So what's an appropriate amount of time for somebody who is going into their first larger development? What's an appropriate amount of time for them to put to the side to say, sorting out the contract between me and the developer is going to take me X number of months?
If they know who they're going to use, I would say a couple of months should be fine.
Okay.
If they don't know who they're going to use, then they need to give themselves maybe another 2 months, because going through a tender process to try and get also takes a bit of time. And if you rush that process, then you can end up badly on the outside of it as well. So
I was going to say as well, if you don't know who you're going to use, then there's an element of trust that you don't have, because if you know who you're going to use, you might have an existing relationship with them.
Exactly, yeah.
But then actually thinking about it from sitting in your seat, that's the wrong way to think about it. You should always have it, regardless of whether you know the person that's going to do it or not. Your contract should always be the same, right? You shouldn't allow any trust to be in there.
Well, yeah, because trust is great, but trust doesn't work in the court of law. So,
yeah,
what the contract says is what will determine where you stand with anyone. So whether
in any given situation,
even if the developer's your brother, even if the developer's your son, it doesn't matter. When you go to court, they're going to look at the contract and they're going to say, well, this is what you agreed. So it doesn't matter what you might have said outside of this, unless you don't actually have a contract in place. But it doesn't matter what you say outside of it. What the contract says is what they'd look at. So
okay, so now looking at a smaller development where the developer is employing the trades themselves. So would you have a contract with each one of the trades?
Yeah,
really?
You would, because essentially what you're doing is you're acting as the main contractor.
Yeah.
And so you would have basically almost, they're called like subcontract packages of work that you have with each contractor, but you have to have a contract in place because someone's work, like one of your contractors' work, may affect someone else's, and you need recourse to claim against one if they've caused issues for another. Otherwise, you end up footing the bill. So like I said in that example, if your plasterer was supposed to finish on Friday, they've gone into Monday, and your electrician was supposed to start on Monday, but they can't, so they've had to start on Tuesday.
Yeah.
And there's a cost involved. You need to be able to put that onto your plasterer because they've taken too long.
Yeah.
So you need to have a robust contract in place with each one.
And what's the lower threshold? You know, if you're doing a homes under the hammer kind of refurb, you know, you're talking about buying something for, you know, 100 grand, and you're going to spend 40 grand in total on the refurbishment. Would you still have contracts in place with each one of the trades?
Always a contract.
Really?
Always a contract. You don't necessarily have to have an onerous contract, but you need to have something that makes it clear what the obligations of each party is. So I'm going to pay you and you're going to do X, Y, Z. Because what we find a lot is, you know, you call a building, you say, oh, I need to do a bathroom. And they give you a quote and they say, yeah, bathroom installation, X, Y, Z, da-da-da-da-da. And then they get onto the project and you haven't told them what bathroom you want. So in your head, you had an idea of what bathroom you wanted, but they've priced in basically the worst bathroom they could get you because it's the cheapest.
Yeah.
And then when you tell them, actually, this is the bathroom I wanted, then they tell you, well, it's going to cost you X, Y, Z. And because they're now doing work on your property, they have a lot more control, because if they don't do it, then you're going to have to go and pay someone else. It's going to cost you even more money to get someone else to come in and finish the work that they started. So essentially having a contract in place that makes clear exactly what you want from them and exactly how much you're going to pay for it, that will protect you in a lot of ways.
So now let's look at the flip side of that and look at an example of when that's gone wrong. So can you talk us through an example of a dispute, basically what went wrong, how it was solved, and what they should have done in the first place to make sure that didn't happen? Yeah,
so I've got a couple of examples in mind, but one that I worked on was a local authority doing some work to remediate some, you know, fire issues that they had on some of their buildings. Because they were very panicky about, you know, legislation and things like that. They were like, I need the contractor to get it done now. So we advised them several times, look, you need to make sure that your contract's sorted with the contractor before you get them started on the project. But they didn't take our advice. They kind of just, a lot of clients, like you said, have existing relationships with contractors. So they'll just say, oh, can you just get started? We'll iron out the details later. Or,
no way.
Yeah, or they use a letter of intent. That's also something that is, for me, is a no-no. But a lot of clients will want to use it because they're in a rush.
Yeah.
So they're like, oh, letter of intent, you can do X, Y, Z up to X amount, and then we'll sort out the contract later.
Right.
But this always causes issues because once someone started something, it's very difficult to then stop it midway. Yeah. And this client basically hadn't decided what kind of materials they wanted to use on the balconies. But they had basically told the contractor, oh, we're thinking of using this person. So the contractor's like, okay, well, if I want to get the work done when they're saying we need to get it done, we need to order the materials now. So they've gone and ordered the materials, they've got it to their site, and then the client's turned around and said, oh, we want this now. And the contractor said, well, I've already paid for this material, so you have to pay for this as well. And so caused a big issue because it was quite a lot of material, probably 50K's worth of material.
Yeah.
And the contractor saying, well, the company's not going to take it back. It's been bespokely created for this project. And the client said, well, that's not what I wanted, so I'm not going to pay. And in the end, we had to explain to the client that because you told this contractor verbally to crack on, and they've cracked on, they're within their rights to get paid for that material. And the only two options are use that or pay for the new material that you now want. So they ended up paying for the new one, and they took the materials, and I don't know if they used it ever.
Wow.
But yeah, they ended up 50k over, and it was only a project for about 300k. So.
And literally the only time pressure was the self-inflicted time pressure on the local authority.
Yeah.
That they wanted to get it done as quickly as possible.
Exactly, yeah. And the thing is, you probably add 2 or 3 weeks to that.
Yeah.
And they would have saved themselves 50k.
So how should they have dealt with that situation? I imagine you're going to say they should have had a full contract in place.
Well, yeah.
That covers everything and goes into detail, right?
And yeah, and if they didn't know what they wanted, they should never have let the contractor start, because what they don't realize is a contractor, in my head, I know that the contractor did that on purpose, because they knew that they were either going to get paid for the materials or they were going to get money to do some other materials. So in essence, they didn't pay 50k for those materials.
Sure.
The client took that back. They would have made the money off of the materials that they ordered, and then made some more money off of new materials they were going to order.
Yeah.
But they almost took advantage of the client because they knew they were in a rush. And in all fairness, they didn't do anything wrong.
Yeah.
But they knew that the client hadn't really decided what they wanted, but they just kind of said, well, you said go, so we're going to continue. And for us, it's like, not to say that people want to be taking advantage of other people in the industry, but contractors are very much, their time is precious to them, because they got to get this job done and then it's on to the next job, because that's the way they make money.
Yeah. By
getting things done quickly. Whereas for a client, that's not where they see their value. So they want contractors to work to their timeline, but it's just never going to happen. So you have to be very clear with a contractor. And I think if they had just taken some time to decide what they wanted to put on these balconies before they told the contractor to start, they would have been in a much better position.
So you've teased us though, haven't you, really? Because you mentioned 300 million beforehand, and the story of 300 million, but then you've just told us one about 50 grand, and it's cost somebody 50 grand. Have you got another one that you can tell us? And is it the 300 million one, please?
I can tell you some details of the 300 million one.
Okay.
I can't go too much into detail because it's like a private case.
Yeah, sure.
But essentially, it was a project which had different phases. So the phases were do a bit of work in one country, move that work to another country, do a bit of work in that country, and then move that work to basically a ship.
Okay.
Because it was going to be on a ship. So as you can tell, it's three very different environments. And it was a very big project. So there was a lot of labor going in each of these phases. But there was a delay that basically meant two things. Number one, it meant that in order to catch up, the contractor had to bring more labor in to do the work. And what you find is you end up paying a premium when you're trying to catch up on time, because you essentially are paying more overheads and for more labor to do the same thing that if you had more time to play with could be done just over a longer period of time.
So for example, just to make that more understandable, do you mean like bringing in agency staff because they're available quickly, but that means that you're paying additional because you're employing through an agency rather than taking on your own employees?
Exactly. Yeah.
That kind of thing, right? Okay.
Yeah, so the contractor might have 100 staff that he's got on a certain fixed rate and they're doing the works, but because...
And that's what the original quote was based on.
Yeah.
Those 100 people doing the work, right?
But now you want to double it up.
Yeah.
So now you've got another 100 people, but they cost double the amount.
Yeah.
So even if they do it quicker, it's going to cost you double. So that's basically the situation that they were in. But the issue was, it is yet to be determined who caused the delay. So one party saying, well, we don't think it was us that caused the delay, so this cost, you have to pay for it, Mr. Contractor. And the contractor saying, no, you are the one that caused the delay, so we're pushing all these costs onto you. And essentially the way that's determined is it will either go to an arbitration or to court, where an independent third party will decide who was the cause of the delay, and as a result, who pays the money. But it can become very nuanced because there can be various different delays. Different people.
Yeah.
And our job is to basically sift through all the information and figure out where the client stands in terms of their liability. So we work with a team who look at the programs and see, okay, we think the delay was caused by you here, but then the contractor here. So you're liable for this amount, but they're liable for this amount, and this is the outturn. So it becomes very technical, becomes very complicated, but essentially our job is to try and help the client understand where we think their position will be and then defend that position when it goes to court.
You're like a property PI, aren't you? You're like a property private investigator, right?
Yeah, a little bit, yeah. We have to dig into the details. We run through, I think, over the last few months, I've been looking at hundreds and hundreds of lines of timesheets. In fact, I say hundreds. I don't know if you've ever been on an Excel sheet. I think the last one I looked at, it went down to about 150,000 rows. So of timesheet data. So yeah, it's a lot of information to take in because there's a lot going on, obviously. And then to add to that, because it's in different countries, you're looking at costs in different currencies as well. So it just becomes very, it becomes very burdensome. And then the other issue is they're trying to catch up time, because once they go onto the ship, the cost to do the work is going to be exponentially higher, because it's going to be a lot harder to do work on the ship than it would be to do it on land. So that's where they are at the moment. So they're kind of just plodding along, doing the work, but there's this whole issue bubbling up in the background of there's 300 million on the table. Who's paying this? So,
So you're like a private investigator and a lawyer putting a case together to support your client, to best support your client.
Yes. Although we have to be very careful with the legal part, because lawyers have a very different view of certain cases.
So when it then goes to the adjudicator or whoever actually makes the decision, like what's the amount of time that it takes them to look through all the information and evidence that you've compiled to then make that decision?
Well, it depends. So if you ever go to an adjudication, usually that turnaround process should be 28 days. So that's what's been put in place in the construction industry to deal with disputes quite quickly. So smaller disputes.
Yeah.
When you have bigger disputes that go to like arbitration or to court, they could be in the court for years.
Right. Okay.
There's been cases that probably started in, I know a few of the people at the company I used to work for were working on cases over 10 years.
Wow.
Yeah, in different countries, like South Africa or Saudi Arabia, places like that. But it's just huge arbitration cases. And it's just because there's so much time and effort to go through the information, it just takes very long. And then the projects are still going. So it's like, it's not even, you haven't even come to the end of the dispute. You're still ongoing in dispute. So a decision hasn't been made. It's just a struggle. And then also the courts are very backed up. So
if a dispute arises, though, the process of going through that dispute sounds expensive, regardless of how much you're disputing.
Yeah.
The whole process after that dispute has arisen sounds incredibly expensive and worth avoiding.
Yeah.
And like you said, with the council, it literally would have taken them 2 weeks. 2 weeks to work out, who's responsible, who wants what stuff they want. And then that dispute wouldn't have arisen.
Yeah, and I think a lot of the time, people, I think Natalia mentioned about design and build before.
She did.
And that was interesting to me, because a lot of people think, okay, well, design and build contract, that means all the responsibility goes onto the contractor now. What they don't realize is that the client is still responsible for the design. The contractor is just the one undertaking it. So if the contractor does a design that complies with your spec to a certain degree, but it's not what you want, then you're responsible for the cost of changing it. So you have to, if you're doing a design and build, you have to be very prescriptive on what you actually want the contractor to design.
Yeah.
Otherwise, you're not going to be able to claim anything from it.
So where would a new property investor, let's look at it from the most accessible form of what we're talking about, which is a property investor doing a single house refurbishment, and they're managing it themselves, and they're bringing in the trades themselves and organising the trades themselves. Where would somebody find these kind of contracts or templates for these contracts? Where do they find that as a guide to help them?
It depends. It varies. But in the construction industry, one of the most popular ones is the JCT contract.
Yeah.
And JCT have various different forms of contract depending on how big your project is. So they even have like a home builder's contract or like a homeowner's contract. So that contract can be used if you're like basically doing works on your home or home that you own.
Yeah.
Because it's a lot simpler and you can pull it together a lot easier. Whereas then when you start getting into bigger projects and stuff, then they have, intermediate contracts and design and build contracts that you can then use for your much larger developments. So I would always suggest JCT homeowners contracts as a first port of call. You might also, maybe you work with a solicitor who does a lot of construction, who can pull together a type of agreement, as long as it fits the description of telling the contractor what they're supposed to do, how much you're going to pay for it, and how they're going to be paid, then it should be okay. But with the JCT, because it's a standard form, it just makes it easier because everyone knows what it says already. It's no like having to read through it and understand it, and you just have to fill in the key information.
Even though it's easy to understand, would you always get a solicitor to look over it before you get it signed?
Not necessarily. I think if you have a competent person that you're working with, or you've dealt with them before, like when we deal with them for clients, they don't have the solicitors look over it a lot of the time because we look at these contracts so much that we can help them understand whether it's okay or not. And with the standard form, unless you're doing loads and loads of amendments to the actual contract, the standard form should be simple enough that you don't need a solicitor to then go through it. But if you're trying to amend it, let's say you want to amend the processes within the contract and things like that, then I would say, yes, you need a solicitor because you could tie yourself up. There's certain things you can't do to change that contract. Like, for example, payment mechanisms. There's a certain law that supersedes any contract. So if you try and change a payment mechanism in a certain way,
right,
if it's not lawful, it's not valid. So those are the kind of things that you definitely need a solicitor to look at.
Do you invest in property?
Yes.
So hand on heart.
Yeah.
Do you follow your own advice?
Oh, 100%. Yeah, 100%. It's almost been drilled into me. Like I couldn't, even when I'm dealing with contractors who are just giving me a quote, I make it very clear what I need. So I break it down item by item. So I understand what they're charging me for every part of the job. Because let's say I say, oh, I need this done. And they say, yeah, it's going to cost you 30 grand. And I don't know how much they're charging me for the kitchen. If I don't need to do the kitchen anymore, they might turn around and say, oh yeah, I was only going to charge you 2 grand for the kitchen. And that's very unlikely that they were going to charge me 2 grand for the kitchen. Yeah. But all of a sudden, I don't have anything to fall back on when I'm taking that work out because it's not clear how much they were going to charge. So all of a sudden, if they say it's 2 grand, it's 2 grand because who's going to tell them otherwise?
Yeah.
So I do try and follow that advice as much as possible. As much as possible.
So now we're going to play a game called Sign or Decline. So I think we can tell that your job and being a QS is a lot about analysing risk, right? And seeing where the problems are going to be and trying to mitigate for those problems, right? So what we're going to do is to make this more understandable for everybody that's out there, we're going to look at different property deals and we want to hear whether you would move forward with that property deal or whether you would walk away from it. So you're, again, analysing the risk involved in that property deal, and then we'll see roughly where your risk tolerance lies.
Interesting.
Sign or decline. Okay?
Right.
So this is the situation, and you need to say whether you're going to move ahead with it or whether you're going to walk away. Okay. Move ahead, walk away. Sign or decline. It's a grade 2 listed cottage. It's 120 grand to purchase. It needs full renovation and modernisation, but there are planning restrictions, obviously, because it's listed. and the planning restrictions are strict and repairs must be approved materials. The GDV is 220 grand. So in theory, is that something that you would move ahead with, or do you think already, because of the stipulations in there, that you would walk away?
Yeah, grade 2 listed is just not something, especially because the GDV is just so close to the purchase price. You're not going to make any money. If they turn around and tell you, oh, you have to use a material that's going to cost you 30,000, that's your deal gone. So yeah, I wouldn't do that because there's just too much uncertainty.
And obviously, if you move ahead with that, you're going to be paying solicitors, you're going to be paying to purchase that property. So you wouldn't incur any costs exploring what materials they want. You just say, there's too many of these decisions involved in this deal are going to be made by somebody else, and therefore I'm out.
Yeah, and added to that, you also need a specific architect to manage that for you, because they're the ones who can discharge the planning consents.
Yeah.
And that's going to cost you an arm and a leg as well. So, yeah.
Out. Next one. An abandoned pub on the high street is up for £250,000. It has potential to convert into 5 flats upstairs and 2 commercial units downstairs. There is no planning yet, but lots of local opposition.
Local opposition like how?
Just people that want to keep it as a pub. The residents around the local area.
Tricky one, because I would say no, because even though it has a lot of potential, if you buy it without knowing the planning situation and your planning gets declined, then again, that's it. There's too much uncertainty. You would have to at least have outline planning before you move ahead with anything.
So again, with that one, would you just walk away because there are too many moving parts in order to get the permission to do it? Or would you put in an offer where you were exchanging subject to planning?
Subject to planning, yeah.
So you would throw a little bit of money at this to see whether it works because of the potential in the deal?
Yeah, if it's only 250 and you could get 5 flats out of it and 2 commercial units, 100%.
It just so happens I've got that unit right now, so let's shake hands and let's do it. I'm kidding.
It's all right.
All right, the third one. A developer approaches you to invest £100,000 in a new build project. Projected return is 30% within 18 months. Okay, so you've got the 100 grand and the developer wants to borrow that 100 grand from you, is the situation. But there's no contract yet and you've never worked with them before.
You're teasing me with that one. That's going to have to be a hard no, because...
Hard no. Again, not even looking into it further.
No, because if there's no contract in place with someone I've never done business with before, I mean, even if I had...
Yeah, but he seems really nice.
I'll take him out for lunch then. And that's about it. Yeah, developments are a risky game because anything can happen. You know, if they hit something in the ground, which means they can't do the development anymore, that's it, that's your money gone. And if you don't have a contract in place, you have no recourse to get it back. So I would at least want to have a whole development plan in place and a contract for my money investing in it.
Okay, last one. Rundown office block is on the market for £400,000. You've been told that it can convert into 10 apartments under permitted development rights. The refurbishment estimate is 350 grand. So you buy it for 400, the refurbishment is 350, and the GDV is £1 million. Okay? But planning still might be a challenge. So you've been told that it can have, it would have PD rights, that it qualifies for PD rights, but that hasn't been approved by the planning department of the council. What do you do?
Can I ask a question?
Of course you can.
Why are the PD rights being approved by the council? Is this prior approval that they need?
Yeah, exactly.
Okay.
Yeah.
I mean, I think that's a bit less risky because there's very few reasons a council can decline prior approval if it's your permitted development.
So long as it qualifies in the category, a category. Absolutely.
The only thing I would say is the 250 that's left in terms of the profit. Yep. You might want to just see if the rest of the numbers stack up, because what people don't realize is there's a lot more to it than just the purchase price and the works cost. You know, you have consultants that it's a bigger development, so you need a bigger team. There's consultants that you might have to hire to do the designs, to manage the project. You may also have to pay a lot in financing costs. So you have to see, do you still have room to make a profit, and will you be making a good enough profit to actually invest in this project?
So therefore, is it worth you putting some money behind this in order to explore that?
Well, prior approval isn't expensive, so yes.
But then you're double checking all the numbers as well.
Well, yeah, I'll definitely. I mean, double checking the numbers isn't going to take long, and it's going to cost me next to nothing. So I would definitely look into it, and then if the numbers stack up and the all I need is the planning or the prior approval, then yeah, definitely go ahead. But I'd probably also think about how long it's going to take to do it, and does the profit. If I could do 3 projects in that timescale that generate a much better profit, then
you go with that. Because you're mitigating your risk, or you're diminishing your risk.
Yeah, exactly.
Brilliant. Thanks very much. So thanks very much for being with us today. Really appreciate your insight and explaining a little bit more about being a QS and also the niche role that you've got into. And also, I've done developments before that haven't had quite as much concentration on the contractors as possibly I should. So it's a good reminder for me that this stuff is important, and I could be opening up myself to £300 million worth of liability that I wasn't aware of. But thanks very much for your time today. Really appreciate it, Paul. Thank you.
Thanks for having me, Chris.
Thanks for listening. If you want to hear more property advice, tips and tricks, then go and have a look at our back catalogue. There's loads and loads of content in there for you. Otherwise, we'll see you here in 2 weeks' time.